Hmm. Very good evening to all of you. I am Vikas Verma, former Assistant Advocate General and co-chairman of All India Lawyers Forum. Today I am moderator of this session. So first, I would like to Lady Lordship, Justice Indra Banerjee, our chief guest, and we have with Madhavi Divan, senior advocate and additional Solicitor General, Supreme Court, and we have with Ardhendu Kumar Mauli Prasad, advocate on record, Supreme Court, and we have with Akshat Kumar Goyal, advocate on record, and we have with Vinod Kumar Goyal, chairman, All India Lawyers Forum. So today's session on the topic of freedom of speech and expression under the Constitution of India. So now may I request to Ardhendu Prasad kindly deliver your welcome speech in respect of our guest. Over to Ardhendu Mauli Prasad.
Thank you, Mr. Verma. Namaskar, everyone, and welcome to today's session. I'm thankful to Mr. Vinod Goyal, Chairman, and Mr. Vikas Verma, Co-Chairman, All India Lawyers Forum, for inviting me to deliver the welcome speech for today's webinar. During COVID times, when everything looks gloomy for the legal practitioners, All India Lawyers Forum has started this webinar series to impart legal knowledge to the lawyers, students and people in general, which has received wider appreciation. The topic for today's lecture has been in debates and interpretation by the courts since independence. From A.K. Gopalan to Shreya Singhal, the Supreme Court of India has been deciding on the rights of the citizens regarding the freedom of speech and expression guaranteed under Article 19(1)(a) of the Constitution of India and the restrictions imposed in Article 92. We have two of the most distinguished personalities from the bench and the bar to enlighten us on the subject. I welcome Honorable Ms. Justice Indira Banerjee, Judge Supreme Court of India, and the chief guest for today's lecture, and Ms. Madhavi Divan, an eminent jurist, senior advocate, and additional Solicitor General of India, who is the keynote speaker. I thank you both for accepting the invitation and sparing time from your busy schedule. Our chief guest for the day, Honorable Ms. Justice Indira Banerjee, after completing her graduation with history honors from the prestigious Presidency College, pursued law from College of Law, Calcutta University. She was enrolled at the bar on 5th of July 1985. Her ladyship primarily practiced at the Calcutta High Court on both original and appellate sides and was elevated to the bench in 2002. She was appointed as the Chief Justice of Madras High Court in 2017 and was elevated as Judge of the Supreme Court on 7th of August 2018. As a Judge of the Supreme Court, we have seen her ladyship as one of the finest, soft-spoken but firm judges. Her observation in Jagdish Arora versus State of Uttar Pradesh that the fundamental rights guaranteed under the Constitution of India, and in particular Article 19 and 21, are non-negotiable, reflects her deep commitment towards upholding the fundamental rights of the citizens. With her vast and rich experience over the years, both at the bar and on the bench, I am certain that her address today would be a very enriching experience for all of us. I warmly welcome Honorable Ms. Justice Indira Banerjee. Our keynote speaker for the day is Ms. Madhavi Divan. Ms. Divan completed her law from Cambridge University and after starting her career from the Bombay High Court, shifted her practice to the Supreme Court in 2007. She was designated as a senior advocate by the Supreme Court in 2019 and currently she is the Additional Solicitor General of India. As a law officer, she has represented the Government of India in several landmark constitutional cases, which include the Triple Talaq case, the NJC case on judicial appointments, and challenges to the Insolvency and Bankruptcy Court. She has authored a book on media law titled Basics of Media Law and is also the co-author of Halsbury's Laws of India Environment. She is the editor of a journal, The Indian Advocate, published by the Bar Association of India. I welcome you, ma'am, for today's webinar. I'm sure that all of us are eagerly waiting to hear our eminent guest on this thought-provoking subject. I now request Mr. Vikas Verma to take over. Thank you so much.
Thank you, Mr. Prasad, for welcoming our guests. So now may I request Ma'am Madhavi Divan, today's keynote speaker, senior advocate, and additional Solicitor General. So now, may I request to ma'am kindly deliver your speech on topic of freedom of speech and expression under Constitution of India. Now over to Madhavi Divan ma'am.
Thank you very much, Justice Banerjee. It's a great privilege and pleasure to have you here. And one thing I'll tell you which you did not mention in your introduction, a little nugget that I am privy to, and which is that Justice Banerjee went to a very fine institution called Loreto House, Kolkata. And that's something I happen to have in common. Privilege. Thank you to all the panelists for inviting me. And this is, of course, a subject which is close to my heart, so it's always a pleasure to speak on the freedom of speech and expression. The freedom of speech and expression is arguably the most basic of all human rights that long predates modern liberal democracies and their constitutions. It is a fundamental foundational value that precedes and transcends the Constitution. The freedom of speech is not the Constitution's gift to citizens. The Constitution merely recognizes this fundamental right, this basic human right, and gives it its pride of place in the pantheon of fundamental rights. The freedom of speech and expression is the sine qua non of any civilized society. And what would we be as a civilization if we were not to have the freedom of speech and expression? Human beings are social animals gifted with the unique ability to communicate with one another through language and also in a myriad different ways. Human beings express themselves through so many different ways, through language, through music, through dance, through art, through mimicry, through films, satire, and lately, of course, through social media. So expression comes in a range of different methods, both traditional and non-traditional. And in order to fully realize the human potential, human beings must be free to express themselves and to open themselves to expressions and thoughts of others. It is on the strength of human communication, the exchange of thoughts and ideas, the freedom to question, to dissent, to test settled assumptions that human thought and philosophy evolve. And it is these values that have culminated in the foundation of modern liberal democracy. Now, the liberal values that are recognized now as the substratum of our constitution, recognized as its immutable basic structure, would not be possible but for the freedom of speech and expression. If we, and particularly in these testing times of the pandemic, where we are forced into isolation and confinement, we are forced into physical distancing, we must remember that we are actually not socially distanced, and that is thanks to technology. We are still able to communicate with one another thanks to technology, and I think that is a great gift we have today, that our lives and livelihoods, much as they are impacted, we must remember what must have happened. We must think of what must have happened 100 years ago when the Spanish flu broke out, when people didn't even have the facility of technology. Perhaps the telephone was available, but it wasn't so ubiquitous. So we must really be thankful. The fact that we are able to communicate even on this platform today is thanks to technology. The freedom of speech and expression is not a standalone right, but the fountainhead of other cherished values in our Constitution. The preamble to our Constitution expresses the highest aspirations of the people of India. The people of India promise to themselves liberty, justice, equality, fraternity. What would these values be without the freedom of speech and expression? Liberty would mean nothing without free speech. Equality, likewise. How would we fight for justice or to obliterate inequalities from society but for the freedom of speech and expression? And likewise, fraternity, which is a very, very important value, not I think we don't talk about it often enough, but fraternity in a country as diverse as us. We need the freedom of speech and expression to be able to communicate with one another, to engage with people who look different from us, who speak differently from us, and who may come from very different parts of the country. So all of these values, liberty, equality, fraternity, would not be possible without the freedom of speech and expression. And therefore, the freedom of speech and expression is the sine qua non of all these liberties. And therefore, it has been described in several judgments as the mother of all liberties, the Ark of the Covenant of Democracy, in judgments right up to Shreya Singhal. Now, Article 19(1)(a) of the Constitution states that all citizens shall have the right to freedom of speech and expression. Article 19(2) sets out exhaustively the grounds on which the freedom of speech and expression may be restricted. Any restriction which does not fall within those enumerated exceptions would be struck down as not permissible. Now, there are 8 grounds on which the freedom of speech and expression under Article 19(1)(a) can be restricted. And of course, you're familiar with them, but I'll quickly spell it out. This is, of course, the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency and morality, contempt of court, defamation, and incitement to an offense. Now, during the Constituent Assembly debates, there was a lively debate on what should constitute the exception and whether there were just too many exceptions to fundamental rights. And one of the charges made was that there are far too many exceptions, so many that they have eaten into the right itself. And one of the points raised during the Constituent Assembly debates was that, look, in contradistinction, look at the American Constitution, look at the Bill of Rights. And that guarantees, according to them, real rights, because there was an absolute declaration in the Bill of Rights on the freedom of speech. Now, at that stage, Dr. Ambedkar explained that it was a misnomer to describe the fundamental right under the US Constitution as being really absolute, because on the face of it, of course, there was a declaration of absoluteness, but in practice, the courts had certainly read into the right various implicit restrictions from time to time. So they were not explicit exceptions, but yes, there were implicit restrictions. And therefore, in reality, it wasn't as if the First Amendment was as absolute as it appeared on the face of it. So in Bennett Coleman, it's interesting that the Supreme Court observes, and I quote this very short portion, the American First Amendment contains no exceptions like Article 19(1) and 19(2) of the Constitution. Therefore, American decisions have evolved their own exceptions. On the other hand, explaining Article 19(2), the court said that the extent of permissible limitations on the freedom of speech and expression are clearly spelled out in Article 19(2) itself. Any restrictions must be on those specified grounds. They should be founded on a law, and further, that law must be a reasonable law. So in Shreya Singhal versus the Union of India, which you know was decided in 2015, a landmark judgment on the freedom of speech and expression, striking down Section 66A of the Information Technology Act. But I mention it here for a different reason, and which is that in that judgment, Justice Nariman makes a real effort to explain the differences between the American counterpart to the freedom of speech and expression and the Indian Article 19(1)(a). And he delineates these differences thus. He said, one, of course, there is no reference to the press specifically under the Indian Constitution, under Article 19(1)(a), because the Constituent Assembly came to the conclusion that the press will enjoy the very same rights as other citizens. And this is true, and I add here that, of course, the press, the media have the same rights under Article 19(1)(a) as any other citizen, except that it is burdened with far more responsibilities, because ultimately the press is in effect a trustee of the people, because they determine, at least traditionally, they determined the sum total of what people would hear and see, what they would know or not know, and therefore they had a very important role to play in determining how vigilant and aware citizens are. Of course, that has changed somewhat with the advent of social media. The second difference is, of course, that the First Amendment to the US Constitution contains a declaration of absoluteness, that the Congress shall make no law which abridges the freedom of speech. Third is, under the US Constitution, the speech may be abridged, while under the Indian Constitution, reasonable restrictions may be imposed. Four, under our Constitution, such restrictions must be justified under one of those 8 enumerated exceptions in Article 19(2). And it will pass muster only if it is proximate to one of those 8 grounds. And of course, in addition to that, it must be reasonable. So I think what is being said here really in Shreya Singhal is that our right under Article 19(1)(a) is quite robust. It's no less. It's probably, in a certain way, it's more robust than its American counterpart, because it doesn't allow for implicit restrictions. In his commentary on Article 19(1)(a), constitutional expert H.M. Sirvai says that in order to deduce what Article 19(1)(a) confers, you have to also look at 19(2). And I would add here that 19(2) really acts like a sieve. You put 19(1)(a) through 19(2) to really deduce what you are really getting as a fundamental right. So the history of these exceptions is also quite interesting, because during the Constituent Assembly debates, there was this lively exchange on what should constitute the restrictions, the grounds of restriction. Now, when the Constitution came into force on 26th of January 1950, there were broadly only 4 restrictions. One was libel, slander, and defamation. The second was contempt of court. The third was any matter which offends morality and decency. And the fourth was undermining security or tending to overthrow the state. But only a few months into the new republic, the newly minted Article 19(1)(a) was immediately almost put to test. The restrictions under Article 19(2) were invoked by 3 different state governments across the country to clamp down on select publications. So in Bihar, you had the government cracking down on a provocative political pamphlet. The High Court rejected the state's contention, and that view was upheld by the Supreme Court in the case of Shaila Bala Devi, the state of Bihar versus Shaila Bala Devi. In Madras, on the other hand, the state banned the Communist Weekly started by Ramesh Thapar. It was called The Crossroads, and he was famously critical of Prime Minister Nehru at the time. And the Supreme Court struck down that censorship order and held that it would be nothing short of an overthrow of the state or a threat to overthrow the state which would justify a restriction under 19(2). And a breach of an order of a purely local significance would not count to justify a restriction. So this judgment in Ramesh Thapar's case was also followed very quickly in Brij Bhushan's case. And therefore, the government was quite worried at the time, because there were this series of 3 rulings. And upset by this series of rulings, the Prime Minister at the time wrote to the then Law Minister, Dr. Ambedkar, expressing the need to amend the Constitution to contain these very subversive, what they regarded as subversive activities. And it was in this background that the First Amendment to the Constitution came about in 1951, expanding the exceptions contained in Article 19(2). So from 4, it moved up to 8 restrictions, and we got public order, security of the state, incitement to an offense, and friendly relations with foreign states. These were the new insertions. But there was one redeeming feature in this amendment which saved the day, and that was the restrictions under 19.2 were now prefixed with the word reasonable. And this enabled the courts to interpret restrictions, and on several occasions, restrictions were struck down when they were found to be not reasonable enough, or not proximate enough, or not proportionate enough. And over time, the court carved out the least invasive test, which meant that the restriction had to be the least invasive inroad into the freedom of speech. And what is very interesting is you will find over time that the very enumeration of restrictions in explicit terms under Article 19.2, which was condemned to start with as eating into the right. As the Constituent Assembly member said, that there were just so many restrictions, it was eating up into the right. But in the end, what seems to have emerged that these restrictions being set out explicitly have emerged the savior and the protector of the freedom of speech under Article 19.1a. Now, since we got our constitution about 70 years ago, undoubtedly, there has been a great advancement in the means through which speech and expression are communicated. And perhaps the most dramatic and tectonic shift has come in the last, say, 10 or 15 years with the advent of the social media. And there are, of course, a range of different laws that regulate the different the media, as in for the print, for example, you have the Press and Registration of Books Act. For films, you have the Cinematograph Act. For theatre, you have the Dramatic Performances Act. For television, the Cable Networks Act. For the internet, the Information Technology Act, and so on and so forth. The fact is that these different media impact the public in very different ways, some more than others. So, for example, in the 1970 judgment, K.A. Abbas versus the Union of India, the court actually justified pre-censorship for films on the ground that films have the ability to impact people in a much greater way. It arouses passions. Justice Hidayatullah says that it has the ability to arouse passions like books and the print media simply cannot. And therefore, he justified a pre-censorship of films. Now, of course, that is being questioned all over again, and there is a pending case in the Supreme Court on whether we should continue to have pre-censorship of films. But the point is that although these there are different laws which are in a sense tailor-made for different forms of expression or different means by which expression is carried, underlying each of them is Article 19.1a, and the restrictions under Article 19.2 remain much the same for each of these different forms of expression. The challenges of the present times are really to be able to adapt a constitution that was made 70 years ago to contemporary challenges. In my own view, I would say that the framers of the constitution were visionary, and the framework which they set for the freedom of speech and expression is one with a rock-solid foundational framework, and yet it is adequately elastic to be able to address the challenges of modern times. And I believe that this Article 19.1a read with 19.2 will hold us in good stead for a long, long time to come. Now, one of the points made when the arguments on the right to privacy were being made before the Supreme Court was that privacy is not recognized as an exception under Article 19.2. And the point remains that yes, it is not an exception recognized under Article 19.2. But if you look at 19.1a itself, you can read the right to privacy under Article 19(1)(a) itself, and I will explain how. So privacy, right? The right to privacy is on the one hand a right recognized under Article 21, the right to life and the right to a life with dignity. But on the other hand, as Justice Bobre writes in his judgment in the Puttaswamy case, that it's a traveling right. So it's not just Article 21, it's not just Article 19(1)(d), which is the freedom to move and settle in any part of the country, but it is also 19(1)(a) itself. So how does it come under 19(1)(a)? Is because if you have the right to circulate, the right to speak, the right to circulate, and to ensure that your speech or expression gets the optimal circulation or dissemination, as was recognized in Sakal papers, then likewise, you also have the converse right, and which is to be able to control the dissemination of that information. If you, for example, if you do not wish your data to be disclosed to somebody, there is also that right to be able to control the dissemination of information, which is, of course, the right to self-determination of information. Informational self-determination is a right which was recognized, as we know, in the Puttaswamy judgment. So it's interesting that 19(1)(a) has two sides, which is, one is the positive right, the right to speak, for example, but there is also the converse, which is the right to be silent, as was recognized, for example, in the Jehovah's Witnesses case of 1986 or the noise pollution cases. So if you have the right to speak or to, your right to put up, say, a loudspeaker would be restricted by somebody else's right to enjoy silence. So there are two sides to the coin, the positive and the converse. Now, moving on, I'll take just a few minutes now on just describing some of the contemporary challenges that we face and how the freedom of speech is being impacted. Now, we all know that technology is the great game changer of our times. It has revolutionized human engagement, unleashed information in ways that we could never imagine. It has been a great democratizer of free speech. It's a medium which is social media, for example, for the people, by the people, of the people. And no longer do you need to be a celebrity or a politician to be heard or seen or followed on social media. So it has shrunk barriers of space and time, and it's phenomenally expanded the access to information, giving us a window into the world in a matter of a few seconds. But the very attributes of technology which have rendered it so free has also limited the freedom of speech in more ways than we have actually recognized. Because that can be very debilitating for speech, because if you do not have control over how wide or far information can reach, who might be offended on some other part of the planet by what you say, then you may not feel free enough or bold enough to express yourself. So it's very important to be able to control. Just as Sakal paper says you have the right to disseminate as widely as you like, you also must have the right to informational self-determination. Because reckless or indiscriminate dissemination of information can be very, very inhibiting for free speech. The other aspect is the notion of intermediary liability. Now, originally, when these tech platforms came up, they were regarded as completely neutral highways of information. So they were quite like a public pin board where any member of the public could come in and put up some content, post some content, and walk away. Now, these tech platforms were not regarded ever, and they aren't really creators of content in that sense. They are only carriers of content. They did not have the right to edit, nor could they actually edit given the nature of the medium. So for that reason, they were entitled to immunity, or what was known as a safe harbor. But today we know that that whole idea of intermediary immunity is undergoing a change because of what we are seeing around us. One aspect is, of course, that we now have come to know that they are not as neutral as they perhaps profess, because the fact is that they do curate content. They use algorithms to decide what you see or you do not see, and the collection of data, data mining has become their business model. So, what you imagine is really free content is not really free. What you are giving is really in kind, your metadata, and that metadata is being traded in, which we do not have enough knowledge about, and we are effectively living in an age of economic espionage, and business empires have been built around this economic espionage. So in the developing world particularly, this is something that we need to be very careful about, because we've seen over the last few years how it has been, there are studies on this, as to how these data mining companies, by trading in people's data, they have actually managed to participate in the subversion even of elections in different parts of the world, and that really amounts to a subversion of democracy. So it is really quite dangerous, and it's something that we need to guard against. So for the developing world, much of the last century was spent in gaining political sovereignty and political independence from Western colonizers. But in this century, the colonizers come in a very different avatar. The East India companies of our times are the data colonizers, and hence the challenges have evolved from political self-determination and sovereignty to data sovereignty and informational self-determination. The other couple of points that I'd like to make here is that, the internet was really meant to be a marketplace of ideas where people could exchange, people with very different views and different ideologies could exchange their views and come together to engage with one another. But unfortunately, the manner in which social media sometimes works is that it has a very polarizing influence, because effectively you end up in echo chambers where you're not engaging with the other, you are only reinforcing the beliefs and ideology that you already have, self-perpetuating those differences at a certain level, and that leads to some very unfortunate polarization. There is also, we see that the propensity for hate speech on the internet, on social media is so much higher. The stalking that takes place, the harassment of women, particularly the threats, the sexual abuse that takes place on the internet is something, that lack of civility that a more anonymous medium has made possible did not happen before, and this is something we need to address. There is also one last point that I'd like to make here, and which is, and particularly, I'm a mother of, well, one teenage daughter and one who has crossed that age, and I find that the over dependence sometimes on a very disproportionate dependence on social media tends to have a not so happy outcome. I think that there is just so much time spent, it's almost an involuntary compulsive activity where we tend to sort of just absorb ourselves in social media, not allowing enough time for pause or self or reflection. And because the freedom of speech and expression were really such haloed values, because freedom of speech and expression were meant to throw up new ideas and new thoughts by engaging with other people. And ultimately, if we are to promote new ideas and new thought, to promote creativity and innovation in society, which is so essential for the progress of civilization, then I think we need to step back and think about whether in some ways the use of social media is actually promoting that or it's debilitating that. So I'm going to end with a quote from a Danish philosopher. I think his name is pronounced Søren Kierkegaard. And he says, people demand freedom of speech as a compensation for the freedom of thought which they seldom use. And I think somewhere we need to step back and think about whether using freedom of speech or speech is safe or really to enhance the freedom of thought and freedom of the mind. Thank you very much. Thank you. Thank you.
Thank you so much, ma'am. Thank you so much for giving the academic and informative knowledge on this topic. And definitely this session would be very helpful to the all academics and advocates and students as well. So now may I request to our chief guest, Justice Indra Banerjee, ma'am. So ma'am, may I request to kindly deliver your speech on this topic, freedom of speech and expression under the Constitution of India. Ma'am, over to Justice Indra Banerjee, ma'am.
A very good evening to all of you. After Ms. Divan has exhaustively covered almost every aspect of the freedom of speech and expression, I must say that there will be very little for me to say because she has covered every aspect. The importance of the freedom of speech can hardly be emphasized. Freedom of speech is the most important ingredient of liberty. The right to freedom of speech is the essence of free society, and it has to be safeguarded at all times. Freedom of speech is non-negotiable. Liberty to express opinions and ideas without hindrance, and especially without fear of punishment, plays significant role in the development of the individual, in the development of the society, and the development of the country. It is one of the most important fundamental liberties guaranteed against state suppression or regulation. To quote Patrick Henry, way back in 1736, the Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government. It is the essence of a democratic polity. The rights conferred under Article 19 of the Constitution of India are not new rights conferred by Divan has in her speech mentioned a number of times. It is an inherent right. It is a natural right. It is a human right which is recognized under Article 19 of the Universal Declaration of Human Rights. The right of free speech and expression benefits as much the speaker as the hearer or the listener. The right to acquire information is very much part of the right, the freedom of speech and expression. And information can only be gathered when opinion is expressed, of course, in a fair manner. The freedom of speech and expression is absolutely essential for unearthing the truth, for pursuit of truth. Ms. Madhavi Divan has already referred to the Constitution of India, particularly the preamble to the Constitution of India. Our preamble is not like the preamble of other enactments because it summarizes the gist of intention of the Constituent Assembly. While interpreting any provision of the Constitution, the preamble is to be considered an integral part of the Constitution and should be treated as guidelines for interpretation of the Constitution wherever there is ambiguity. In the Keshavananda Bharati case, the Supreme Court clearly held that the earlier view taken in Berubari Union that preamble was not part of the Constitution was incorrect, and that the preamble was very much a part of the Constitution. Our Constitution is basically people-oriented. The preamble of the Constitution starts with the words, "We the people of India." We the people of India, having solemnly resolved to constitute India into a sovereign democratic republic. Of course, the words secular and socialist were added later by the 42nd Amendment. The people of India, having constituted India into a sovereign democratic republic, promised to secure to all its citizens justice, social, economic, and political. What is political justice without freedom of speech and expression? There can be no political justice. Similarly, people have to raise their voice against social injustice or even economic injustice. We will find the next is liberty of thought, expression, belief, faith, and worship. Now, this liberty of thought, liberty of expression, it is a thread which runs through all the rights and freedoms which have been referred to in the preamble to the Constitution of India. Equality of status and of opportunity has been promised. How can there be equality of status if one group of people do not have the right to express their views, to express their opinion? And then, of course, fraternity, assuring the dignity of the individual and the unity of the nation. Now it is unity and integrity of the nation. What is fraternity if there is no? The whole idea of education, the right to education is also a basic right. And the object of education is that one should be able to contribute to society. And this is through freedom of expression of one's views and ideas. One learns and one also imparts information. Article 19(1)(a) of the Constitution guarantees that all citizens have the right to freedom of speech and expression, as we have been discussing all this while. This right is available to every citizen of India, but it is not available to a person who is not a citizen of India. Then what about the corporate body? A corporate body may not be a citizen of India, but The shareholders, they have a right under Article 19 of the Constitution of India, as has been held by the Supreme Court time and again. In one of the earliest judgments on the freedom of speech and expression, that is Ramesh Thapar versus State of Madras, to which a reference has already been made by Madhavi, the Supreme Court Chief Justice Patanjali Sastry observed, the freedom lay at the foundation of all democratic organizations, for without free political discussion, no public education, so essential for the proper functioning of the process of popular government, is possible. A freedom of such amplitude might involve risks of abuse. But the framers of the Constitution may well have reflected with Madison, who was the leading spirit in the preparation of the First Amendment of the Federal Constitution, that it is better to leave a few of its noxious branches to their luxuriant growth than by pruning them away to injure the vigor of those yielding the proper fruits. In the same judgment, the court held that public interest in freedom stems from the requirement that members of the democratic society should be sufficiently informed that they may influence intelligently the decisions which may affect themselves. As Madhavi has already pointed out, the freedom of expression was introduced into the American Constitution with its First Amendment when the Bill of Rights was introduced. There are no restrictions, and freedom of the press is expressly included in the right to freedom of expression, unlike in India, where freedom of press is not included as a right to freedom of speech and expression, but it is implicit in the right. It is important to remember that our Constitution was framed almost 200 years after the Federal Constitution of the United States. And by the time our Constitution came to be framed, lacunae in constitutions which did not streamline the restrictions came to surface. And the constitution makers did not want to leave loopholes, and they tried to plug all of them. Of course, by the First Amendment, the restrictions were increased. Freedom of expression serves. It helps an individual to attain self-fulfillment. It assists in the discovery of truth. It strengthens the capacity of an individual in participating in decision-making, and it provides a mechanism by which it would be possible to establish a reasonable balance between stability and social change. Our Constitution is a vibrant, living document. It has undergone many interpretations. Madhavi referred to the judgment of Justice Nariman in Shreya Singhal in great detail. In fact, the Supreme Court has gone to the extent of saying, in the case of Navdeep Singh, Johar versus Union of India, that The validity of Section 377 of the Indian Penal Code is to be examined on the anvil of Article 19(1)(a). And in that case, the Supreme Court observed that public decency and morality cannot be amplified beyond rational or logical limit. These were found not to be reasonable grounds for curbing the freedom of expression of the LGBT community. The court was of the view that consensual carnal behavior in private state, whether it was homosexual or heterosexual, did not harm decency or morality. This is a great jump in interpretation of the right. Right to express one's thought is meaningless if it is not accompanied by relaxed right to secure all information on matters of public concern from relevant public authorities. However, to ensure that there is no harm in inserting the freedom of information on a specific corollary to Article 19 of the Constitution, freedom of speech and expression has long been a hallmark of healthy democracy and a free society. In England, this right was enjoyed as a result of the application of the principle of the rule of law. Under English law, the freedom of expression is, of course, intrinsically important, though England does not have a written constitution, as in India. In the context of freedom of speech, I would like to quote from John Milton's Areopagitica. The freedom of speech is that freedom which promotes the discovery of truth. He says, John Milton says, give me the liberty to know, to utter, and to argue freely according to conscience above all liberties. In Abraham versus United States, Justice Holmes said, the best test of truth is the power of the thought to get it accepted in the competition of the market. In Regina versus Secretary of State for Home, Lord Steyne explained that freedom of speech and expression is the lifeblood of democracy. Since I will not repeat what Madhavi has said, the right is both positive and negative. It is an affirmative right to express. It also takes within its fold the right not to speak, the right to keep, the right to remain silent. The Indian judiciary, as I've just said a little while ago, has been enlarging the area covered by the fundamental right to freedom of speech and expression, which is a vital feature that a democracy runs with. The Supreme Court at many times has said that the words freedom of speech and expression must be broadly construed to include the freedom to circulate one's own views by words of mouth or in writing or through audio-visual instrumentalities. It therefore includes the right to propagate one's views through the print media or through any other communication channel. For example, the radio, the television, and now, of course, the social media or the internet. The court has held that these rights are great and basic rights which are recognized and guaranteed as the natural rights inherent in the status of a citizen of a free country. The freedom of press, though not expressly included in Article 19(1)(a), is implied in the said article. The freedom of expression includes the freedom to propagate one's own views and the views of others, and freedom to communicate views to others, and this can be done through the press. To quote Justice Marshall in Law of the Press, it is the liberty of the press that is guaranteed, not the licentiousness. This is important to remember. It is the right to speak the truth, not the right to bear false witness against your neighbor. Every citizen has a constitutional right to the enjoyment of his character as well as the ownership of his property. And this right is as sacred as the liberty of the press. As there is always a class of moral perverts and degenerates in every community who feed their morbid appetites upon such scandals and rejoice at the injury thus done to those who are infinitely their superiors, that they are not worthy to fasten the latches of their shoes. But to the credit of the newspaper's profession, it is due here to make a record of the fact that the great majority of the members of that profession do not approve or sanction such practices or such yellow journalism, but have a proper appreciation of the rights and purposes and functions of a newspaper, and deplore the fact that such unworthy persons are engaged in the profession. The contrast between the two classes marks the differences between respectability and indecency, between intelligence and ignorance, between law-abiding patriotic citizens and the converse, the assassin of character for the accumulation of lucre. The great body of people condemns such practices and such miscreants, and the courts would deserve condemnation and abolition if they do not vigorously and fearlessly punish such offenders. Such practices are an abuse of the liberty of the press. While scurrilous, inflammatory articles in the press can be controlled to some extent, the social media has become quite a menace in this regard. Blackstone, in his commentary on the laws of England, while dealing about the freedom of press in England, observed as follows: the liberty of the press, properly understood, is essential to the nature of a free state, but that this consists in laying no previous restraints upon publications, and not in freedom from censure for criminal matter when published. Every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press, But if he publishes what is improper, mischievous, or illegal, he must take the consequences of his own temerity. To quote Lord Denning, every country preserves to itself the right to prevent the expression of views which are subversive of the existing constitution or a danger to the fabric of society. Free and frank discussion and criticism of matters of public interest must in no way be curtailed, not in any circumstances, but there comes a point at which every country must draw the line, and that is when there is a threat to overturn the state by force. Having regard to the paucity of time, I'm already running out of time. I will not refer to the plethora of judgments of the Supreme Court on freedom of speech and expression, Virendra versus State of Punjab, with regard to banning of newspapers. The court held it is certainly a serious encroachment on the valuable and cherished right to freedom of speech and expression if a newspaper is prevented from publishing its own views or the views of its correspondents relating to or concerning what may be the burning topic of the day. Our social interest ordinarily demands the free propagation and interchange of views, but circumstances may require a reasonable subordination of the social interest in free speech and expression to the needs of our social interest in public order. The Constitution recognizes this necessity and has attempted to strike a balance between the two social interests. It permits the imposition of reasonable restrictions on the freedom of carrying on. Of course, it goes on to trade or business with which we are not concerned. Commercial speech is also permitted under Article 19(1)(a). It's part of the freedom of speech and expression. Commercial speech to promote products, etc. The right to issue advertisements is also guaranteed under Article 19(1)(a) of the Constitution of India, subject, of course, to the restrictions contained in the Constitution. Madhavi has referred to the various restrictions. Sub-Article 2 of Article 19 reads that nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly public order, decency or morality, or in relation to contempt of court, defamation, or incitement of an offense. It is important to remember the expression that nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law. Therefore, there has to be a law under which freedom of speech can be restricted and not otherwise. And at the cost of repetition, the restrictions have to be reasonable. The voice of the people cannot be gagged under any circumstances. Now, let us say law relating to contempt of court. Freedom of speech does not confer the right to commit contempt of court, that is, to lower the dignity and majesty of the court by making scurrilous remarks. However, it is important to remember that fair criticism of a judgment or a fair criticism of a policy perhaps does not constitute contempt, and this has been decided by the Supreme Court itself and by the other courts time and again. It is part of the freedom of expression to express one's opinion with regard to a verdict of court. While the right to freedom of speech and expression is an absolute right, subject only to restrictions by law in respect of matters specified in Subarticle 2 of Article 19, it is important to remember that a person's right, there is a limit to a person's right, and that right ends where it infringes or encroaches upon another person's right. Let us say a person's right to privacy, a person's right to dignity, so on and so forth. We are very conscious of our rights, our fundamental rights under the Constitution of India, but we often forget a chapter which was added by the 42nd Amendment of the Constitution of India, the chapter on fundamental duties, Article 51A of the Constitution of India. The time has come to think whether the right to freedom of expression has to be balanced with the obligations of a citizen, the fundamental duties. True, the fundamental duties may not in themselves be enforceable. However, let us say one of the fundamental duties is to renounce practices derogatory to the dignity of women. Now here, inciting speech which is derogatory to the dignity of women, which encourages practices derogatory to the dignity of women, such kind of speech, such kind of articles should and perhaps can, in my view, be restricted by reference to the Constitution itself. To conclude, there can hardly be anything to add to Madhavi's very exhaustive speech. I repeat that the right to freedom is a very basic right. It is not negotiable and it ought not to be curbed except strictly in accordance with law and strictly in accordance with Article 19. of the Constitution of India. It is the very essence of a democratic polity. The right to express one's opinion, to enable others to deliberate, and as pointed out in the Shreya Singhal case, freedom of speech may give rise to discussion. That is certainly permitted. One is permitted to advocate an idea, to push across one's idea. But what is perhaps to be frowned upon is inciting an illegal act, public disorder, and the like. Thank you very much. I think I've run out of my time. And I thank the organizers for giving me the opportunity to share my views on a topic which is very close to my heart. Freedom of speech and expression, the very essence of democracy.
Thank you so much, Lordship, for your kind and thought-provoking words, and you expressed thoroughly on the topic of speech of right to speech and expression. And now, before the vote of thanks, now may I request to Vinod Kumar Goel say a few words with regard to our organization. So over to Vinod Kumar.
Thank you, Vikas. With the permission of Lordship and our keynote speaker, I, Vinod Kumar Goel, Chairman of All India Lawyers Forum, feel elated and honored to introduce this organization to all of you. A short introduction of organization is that this forum came into existence in 2009 with a group of young lawyers, professionals, and different legal background, unanimously decided to form an organization that breaks the regional barriers and unites the legal world. The firm is actively working in more than 23 states as of date, that we have brought the legal professionals of 23 states under one roof. This shows that we are moving in the right directions, and soon the nation will witness a new sunrise in the legal profession. It has been formed to save the future of the legal profession throughout India, with the aim to support the legal profession by offering access to practical resources for legal professionals to help improve the administration of justice, establish ethical codes, and develop a professional network. The All India Lawyers Forum is committed to enable opportunities for equality professional development, support the enhancement of quality in the legal profession, promote the delivery of justice, facilitate effective law reforms, and advance the rule of law for the people. Today, I am very glad to inform here that during this pandemic period, the All India Lawyers Forum has conducted more than 28 webinars on the different topics, including the lecture series with regard to the Advocate on Record exams with the eminent speakers, for which I and my team is highly grateful to all our chief guests and keynote speakers of the webinars, including today's chief guest, Honorable Justice Indira Banerjee, Judge Supreme Court of India, and today's keynote speaker is Madhavi Divan, Senior Advocate, Additional Solicitor General of India, for giving their valuable time and to share their views on the topic. I am also very thankful to each of one of my team and to support and guidance, and who are working really very hard and not leaving any stone unturned for uniting the legal fraternity. I welcome your ideas and suggestions to make us even better to showcase our
Just a minute, please. Just a minute, please. Please excuse me. Please let me leave. My sister is admitted in the AIMS. I'll have to go and see her. She is very seriously unwell. so I need to go and see her. So I'm leaving the. Thank you very much.
Thank you.
Thank you very much. Thank you very much. We are very we are very grateful to you, ma'am. Thank you very much. Thanks to giving your valuable time.
No. So now may I request to Akshat Goel, kindly deliver your officially vote of thanks. Akshat,
Thank you,
over
Mr.
to
Verma.
Akshat Goel.
Now, today, I, Akshat Goel, on behalf of All India Lawyers Forum and its various teams, take this opportunity to thank our chief guest for the webinar, Honorable Mrs. Justice Indra Banerjee, for giving and enlightening us with her so very valuable views and observations for the topic of the day. I further express our sincerest gratitude for our keynote speaker, the very esteemed ASJ and senior advocate, Ms. Madhavi Godaria Divan. Madam, it was indeed a pleasure listening to you. Ms. Divan's insight on the right to speech and expression under the Constitution of India were very valuable and are very welcome in these most trying times when the movement itself is restricted because of the prevalent pandemic. I further thank all the participants who have specially logged in for our today's webinar. I am highly grateful to the Honorable Ms. Justice Banerjee and Ms. Ms. Madhavi Godaria Divan for taking out time from their very busy schedules and enlightening us and giving us their speeches on the very topic. Now, finally, I call upon our team, which has been our strength, and thank each one individually as under Mr. Vinod Kumar Goyal, Mr. Vikas Verma, Mr. Abhinav Singh, Mr. Surveer Sidhu, Ms. Rashmi Bansal, Mr. Vikrant Dhama, and Mr. Naveen Gupta Advocate, Mr. Balraj Puri, Mr. Manvinder Singh, Ms. Pragya Parajit Singh, Dr. Professor Mohit Sharma, Mr. Sandeep Garg, Mr. Bikramjit Singh, Mr. Amandeep Singh, Mr. Udit Mendirata, Mr. Dipesh Kumar, Mr. Sagar Sharma, Mr. Dipender Singh Malviya, Mr. Anil Kumar Jaldi, Mr. Bhagyodaya Mishra, Mr. Furkan Sofi, Mr. Biswajit Hazarika, Ms. Jahan Ara Kulsum, Mr. Suvajit Ghosh, Mr. Durgesh Gupta, Ms. Sandhya Singh, Mr. Chandrasekhar, and all our student wing coordinators and all other members of the forum whose name I may have missed out. Now it's over to you, Mr. Verma.
Thank you so much. Thank you so much, ma'am. So now may I think, end the broadcast.